Hi there. Hope you're doing well. Just been watching a few videos today, as is the usual. Fantastic video on Lucy Letby analysis channel, like the 20 areas or 20 points, if they had been done differently, or things had not been done that could have stopped it reaching this debacle, or this terrible tragedy, this crime against justice, crime against innocent Lucy Letby happening. I've just started watching the next part of Stuart Gillham's interview with Dr. Martin Pittman, which is a fantastic interactions and information coming across there and explanations. And this one is to do with baby C, and as I said yesterday, watched the ducking stool. That's fantastic. And Jenny's video yesterday, and also Jenny's video about a brilliant video about sort of a fantastic one, using some imagery of the heart and showing how all the lines are put in and where they may end up, where they may migrate to. That's great. And I'm just mentioning these in case some people haven't seen them yet. And then there's another short one that Jenny did, which is great, about Breary's one of his charts that he drew up, which apparently was to suggest that the Countess of Chester wasn't an outlier in terms of staffing and all the kind of tricksiness he was pulling over there. I think people on Twitter, some statisticians, are just kind of, they're wise to what he was doing there, really, because he's not really looking at any kind of nuance about, as Jenny describes in the video, about levels of skill and whether there's a sufficient senior cover there at all or anything like that at all. He's just using some kind of gross figures just to make it look as though the unit COCH is above average. But why I wanted to do a video, today, I should say, is to do with Evans. It's a bit of a continuation of what I was saying yesterday about him going beyond his remit when he's sort of getting in full amateur detective mode and sort of going to find out who's done something in his mind, but who the guilty party is, as it were, suggesting rosters, then looking through the roster himself. It's all completely nothing to do with him, but it goes way beyond that, actually, and it got me thinking what should his limitations have been vis-a-vis the police, and then also what should his limitations have been in the courtroom, and are those two separate things? And I put this in my notes here. I put how many Dewi Evanses are there? And there's quite a few, in a manner of speaking. The first one I consider is, well, there's his historical self with all these other awful cases, situations he's been involved with and causing great harm. So there's that area. I didn't really think about that when I was thinking about this video here, what I'm doing now. But the first speculative area, well, it is speculative, is, was he in a relationship of some sort of interaction between the group of consultants, or one of them, or somebody from Countess of Chester Hospital, or an intermediary who was filling him in with details of what was going on in Chester before, I think it was the 17th of May that he writes the email to his mate at the NCA. Forgotten that guy's name. Nick at the NCA, who since has left or something, or was removed or whatever. In other words, prior knowledge. That's one Dewi Evans. That's one incarnation or version of him, or one role he's in, or one sort of separate area that. And I know that's speculative, but I suspect highly that that exists. We haven't proven it yet. We haven't shown it. We haven't evidenced that in any way at all. But I know quite a few people have grave or deep suspicions that does exist. The next one is when he meets with the police, and then he's on board then, really, isn't he? And he's obviously, and then the degree to which he has direct interactions with the consultants at that point. Let's say he hadn't had them before. I think he had, but let's say he hadn't. What kind of interactions was he having with them, but with the police as a kind of intermediary, or even directly? I suspect all that and more, all the possible combinations and more, direct intermediary, police as intermediary, and going the other way as well. In other words, feeding from Evans through the police as the intermediary to the consultants and back. So it's just a hot mess of collusion, basically. So there's that, but there's him in his role of what he's been hired to do. And is that distinct, and should it be distinct, or should it be allowed to be distinct from how he behaves, or what he's allowed to say in the court, the strictures that should be placed upon him as a witness in the setting of a court? Has he got a different parameter? I'm not saying whether he should have or shouldn't, but did he have a different parameter of the way he behaved with the police? And I think he did. I think he was obviously, him rocking up there with the old 10-minute thing, cup of tea and a country slice, and he's saying, well, that's your first murder, essentially. That's deliberate harm. I wanted to bring up this thing from 2015. He's involved in a case, Dewi Evanses, with another doctor, a female doctor called Dr. Primrose. And this case is about two children called children called A and B. Now, this court document you can find is with regard to an appeal that the family, the mother, the person who was accused of abusing child A or B, A and B, with a head injury and an injury to the ear and certain other injuries. And at the first trial, it was deemed that the injuries had been non-accidental, with the help of Dewi Evanses and Dr. Primrose's input. Then an appeal was brought, and this is kind of I think where this ends here actually is that the children are taken away because it's deemed that in the first trial that deliberate harm was done, abuse. There was abuse of these two children, A and B, by the mother, I think, and but there's other family members come into it. So exactly who was guilty, but the idea that they were split off from the family, these children, they've gone into care essentially. There was an appeal against that, and this is a judgment. This is a judgment by J. O'Hara, and it's in 2015. It's in so this is right in the indictment period in September 2015, and it's this judge's hearing the application for appeal, as it were, because in the end he orders the full appeal, and he in the interim returns the children to the family. But so here this J. O'Hara is going over the details of how the initial case was found, and he's looking at Evans's his reports, but also the scope of what he allowed himself to say and to do, and also the other doctor that was working with him. I'll put the link below because it's fascinating. It's listed in points. There's point 15. My voice is going again. I've got to slow down. I want to read out point 15, and this relates to Evans's latitude that he gave himself, first when he's working for or with the police, and then with the CPS, and then secondly when he's in the court itself, and whether he goes beyond the bounds of what he should be saying then and what he should be inferring, and indeed in the substance of the reports themselves. Are they going outside of his required or necessary bounds or borders of what he should be saying as a medical witness? I think so. I know Chris on Lucy Letby Analysis and many other people have done a lot of work on analysing Evans's statements in court, and it would be a case of like going through everything he said and saying, in this case, is he stepping outside? In this case, is he stepping outside? And I know that's been done to a certain degree already. I want to read this point 15 from this judgment. This case is in Northern Ireland, but Evans got involved in it as an expert witness, So this is what the judge is saying, who's deciding to give an appeal to the family, essentially, and he has returned the children to their parents before that appeal happens, while they're waiting for it to happen. This judge here, looking in the Court of Appeal, is saying, in his judgment, the trial judge, so he's referring back to the original trial about child A and B. This isn't anything to do with Lucy Letby. This is a different case altogether, to do with potential child abuse, In his judgment, the trial judge was critical of Dr. Evans. Oh, there's a novelty. Suggesting that his evidence should have been more considered and structured than in fact it was. I accept, that's this Court of Appeal judge, I accept that there is some justification for that criticism, but however frustrating changes in opinions are, well, we know he's good at that as well, Evans, don't we? I should stop interjecting. Anyway, I'll finish this bit off. However frustrating changes in opinions are, this is a case in which both experts, that's Dr. Primrose and Dr. Evans, I'm not sure if they're both on the same side now or they're on alternative sides. I think they might. Anyway, I think they're on the same side in the original case, but I haven't got the papers for the original case. I haven't got that. This is a case in which both experts were clearly unsure about expressing an opinion about whether the injuries were non-accidental, i.e. deliberate, but both did so because they had been asked to and were expected to do so. I'm kind of inferring from here, perhaps they were on different sides, and whatever sides they were on, but it's all about what the opinions are that they expressed and whether they went beyond what they should have done. So just read that bit again. This is a case in which both experts, so Evans being one of those, in quotes, was clearly unsure about expressing an opinion about whether the injuries were non-accidental. Unsure. Well, he made up for that since. He really went for it, didn't he? But they did so because they'd been asked to, and they were expected to do so. So who asked them? I'm assuming maybe the police investigating it, and then the prosecution, defence, for both experts, either way. But this is the crucial bit of what this Court of Appeal judge says. That approach is entirely wrong and must be avoided in future. It is definitely not the role of expert witnesses to tell the court whether they believe injuries are accidental or non-accidental. So this has massive relationship to obviously what he did all the way through, obviously with the police, but also in court, surely. That is especially so in cases such as the present, and lawyers should be far more alert to avoid drafting letters of instruction to doctors, inviting them to express their opinion on that issue. So he's having a go at the original lawyers there. But when we're thinking of the Lucy Letby miscarriage of justice, it's also about the relationship of the police to Evans, about what they were asking him to do, expecting him to do, and then he delivered, and he went way further than that, a country mile further, or 10. And he goes on in part 16 here. I'll link it below. It is for the trial judge to decide whether on all the evidence, not just the medical evidence, that the trust, it must have been some kind of trust who was involved in the original case, proved that injuries are non-accidental. There's another bit I want to look up, so I'm just going to scroll down a minute. the two injuries in this particular case are a skull injury and then a slightly less severe injury to an ear of the two children. There's a kind of list of conclusions at the end here in this finding by this. I don't have all the legal parlance, but in this kind of finding by this Court of Appeal judge, who was then ordering a full appeal, as it were, and has returned the children to the family. It's another bullet point. He kind of reiterates it here. He says, in cases involving injuries to children, medical witnesses should not be asked to express an opinion as to whether the injuries are accidental or otherwise. So going back to this concept of, like, there are many different versions of Evans, I want to just pause this area for a minute and just say, well, what other versions? There's how he conducted himself in the court and what range he allowed himself to occupy in terms of the range of opinion he allowed himself to give, and did it stray, and when did it stray outside the parameters of what it should have been contained within, where did he stop being a medical witness and start being in the court effectively like a policeman or a detective, or and it's around the area every time, surely, as to whether, and this is why I'm doing this video today, because it's a continuation of the idea that he shouldn't have been trying to help the police find a suspect. That has nothing to do with his job. But more than that, crucially, he shouldn't have been involved in anything to do with legal determination of guilt or intent, specifically intent as well. Certainly legal determination of guilt. But when he rocks up to that police station and you've got this thing, the 10-minute thing, there's deliberate harm there, he's already in the world of intent. And that's where he stays. And he never leaves there. And maybe he dials it back in the court somewhat when he's presenting there. But his relationship with the police is totally one-off. He's done two things. I said yesterday in the video, he morphed into part of the gang of consultants at COCH, but he also morphed into Operation Hummingbird. So that's another kind of version of him. He becomes a temporary investigating officer. And what's so dreadful about it is that Hummingbird and the goons that are running that and populate that ridiculous operation are all too happy for him to do that. They've got no idea whether he's overstepped. They don't seem to know whether he's overstepping the bounds at all and doing what is in their wheelhouse or their responsibility to do. So it's all about Evans's moving into the realm of intent. So following on from yesterday, it's much worse than the idea that it takes it that much further. So he's gone into intent and then he's focusing on a suspect, Evans. He shouldn't be doing that at all. But he wouldn't have got to that point if he hadn't been focusing on intent rather than describing what his... So that got me thinking, well, what should be the boundaries of what he was saying to the police and then in court? What should be the absolute boundaries? I try to begin thinking it through. And would it be something like, okay, from his perspective, it's not giving his theories any credence, but could he not have said, could he not have left it at this? I can't see from the medical notes that there's any natural cause of death in this particular instance, even though he's wrong about all that, but let's just park that for the moment. I can't see that it was a natural cause of death, and I can't see from the medical notes any failures of the care that would have brought about the death that wasn't a natural cause of death, i.e. like medical negligence. But he should never have strayed into intent. And I want to now, I hope this isn't too all over the shop, because I'm trying to move between different views of Evans and back to this idea of multiplicities of Evans. It's a horrific idea, isn't it? But Evans then becomes something else post-conviction. He becomes a sort of mini celebrity. He's known, he's kind of like given like a nickname, like he's the one, he's kind of solved it. Like he's a sleuth, and they're calling him that in sort of, kind of not jokey way, but in a kind of offhand way in some articles. He's this wizard, this sleuth, this detective. They're kind of acknowledging that he's the detective almost in the reporting, talking about in 2023 here. And then he's dining out on it, and he's appearing everywhere he can. And then he's making it very personal about what he feels about Lucy Letby, and he's being invited to do that, and he's doing it. None of the other experts from the prosecution are. None of them. Only him. He's enjoying it. He's enjoying his moment in the sun. He feels like a hero. He's acting like one in his own lunchtime. And it's all about intent there as well. And I know, okay, the convictions have happened, but still, that's the Evans we've come to know, and many of us deeply dislike and distrust and disparage, because, and I began to think, had we not seen him in any interviews, had he not appeared anywhere in print interviews, or had he not done any exchanges with Peter Alston, had he not done anything at all, had he been as quiet as Dr. Marnaridis, for example, or any number of the other prosecution witnesses, it's not that we would then find his work more convincing. It's nothing to do with that. But we wouldn't have seen his grandstanding. We wouldn't have seen his callousness. We wouldn't have seen any of the personal apparent enmity he has for Lucy Letby. And I think that's all wrapped up in the fact that it's all projection. It's all wrapped up in the fact that he knows he's put somebody who's absolutely innocent in prison for life. And if that's overturned, the focus all comes back onto him, as it will do. As many people have said in comments, they will turn on him. The police will turn on him, because that's their only direction of travel, really. That's one of the things they'll do, that, being kind of institutionally cowardly as they are, the police. I believe that's the case. They will turn on him to the degree that they'll try to absolve themselves, absolutely. And that's the institutional cowardice and lack of honour that the police have generally. I'm afraid that's how I view them. So yes, back to the idea of the medical witness should avoid legal conclusions. And I know he's not in court when he's dealing with the police. He's being hired, being paid by the police up to the point of charge, which is 2020. Thereafter, he's paid by the CPS, but he's in the midst of legal conclusions right from the beginning, within 10 minutes, essentially, isn't he? He tells us that, so we don't have to guess. It's all about. It's all about he knows what the intent is, and also then he knows who it is as well, and he's told who it is, and he pretends not to know, but he knows who it is. And then he bolts the intent on there as well for the police, which they shouldn't allow him to do, and he shouldn't be doing. But it's just like a marriage made in hell. That kind of dozy, clueless, lazy, absurd Operation Hummingbird. The goons are in there. You join that up with an Evans, and you've got this unholy mixture of just ghastliness that has led to this. And then the arseholes at the CPS, as the cherry on the cake, and then you get somebody like Johnson as the hitman, and then you've done it. And that's what they've achieved. So there's these different, in my mind now, there's these different kind of Evanses. It's all the same person, but he's moving in different, through time, he's moving into different kind of incarnations of himself as the course of the investigation goes through, and then he's in the role of the witness in the court, and then afterwards he's his mini celebrity. And then there's another incarnation that's happened more recently, and that's the one when he knows he's on the ropes, when he knows he's been found out, when there's building criticism and opprobrium coming his way, and he knows all about it, and he knows that the actual experts are on his case, and they've just demolished everything he's done. And so that's another kind of version of him, or a kind of stepped up version of him, in which he's in full flood fighting mode. And so he has to become almost like a caricature of himself. And the classic one is the end of the article that he did in The Guardian with Felicity Lawrence. Just get it through your head. She murdered that baby. Get it through your head. So how far are we there? And I know he's not in the court when he's saying that, but nonetheless, as a ostensible medical witness, how far has he drifted away from not expressing opinion about intent or making legal determinations of guilt, which are nothing to do with him and never should have been anything to do with him at all. And just to sort of continue that a little bit, wonderful channel, A Liberated Mind, did some fantastic in-depth looks at this, particularly to do with Goss's summing up, but also lots of other areas as well to do with Evans. And he was looking at the legal terms, mens rea, actus reus, the guilty act, and then the mens rea, the guilty mind. And I think Tea Break with Tasha also did some work on that as well, explaining that. So that's just another way of looking at it in terms of Evans, really. When he's gone in there with the 10-minute thing, and he already knows, and he's acknowledged that, he knew that somebody was in the frame, as it were. Somebody had been removed from the unit. So there's a specific suspect there already. And he's just, what Evans is doing, he's building on the idea that there's deliberate intent that the consultants have been running with for 2 years. So that's the idea of him joining the gang, essentially. And then the police welcome the new enlarged gang as their greatest helpers in order to crack this case. The police did nothing to investigate this case. Nothing at all. They just kind of stood back almost and did some stuff to make it look as though they checking the gutters, kind of make it look bit of theatrics to make it look as though they're doing something. But actually, it was the consultants at Evans that did it all for them. And they just sort of the ones that kind of prepared the documents and sent it to the CPS. But they had it all done for them, really, essentially. But back to this actus reus, mens rea, the guilty act and the guilty mind, the two components you need to determine that a crime has been committed. When he says that this baby, he uses the term, Evans, this baby was put in harm's way. And areas he doesn't consider, and certainly doesn't seem to consider at all, is the idea of whether the idea of accidental versus non-accidental. And as we go back to that judge in Northern Ireland, the judge's findings is that he shouldn't be even doing that. But that even that doesn't enter his world. It's either natural causes, it would seem. It's natural causes or it's murder. There are other, as we know now, obviously from Shuley in the panel and Dr. McConville and Dr. Martin Pittman and so many other people, and what Jenny's doing on her channel as well, and so many other people, and Dr. McLachlan before that, and so many. I can't list everybody, but there's loads of amazing people, and Shuley in the panel, etc. I've lost my thread there. Let me think a minute where I was going. Sorry, I lost what I was going to say. Anyway, when he's in, maybe I'll find my way back. When he says, like, in 10 minutes, the baby's been put in harm's way. I mean, that term is, I don't know exactly what he means by that, but what might it encompass? But for him, it's deliberate harm, not accidental harm, not harm through negligence. He's not talking about, and never talked about, harm through negligence, has he? And we know that because subsequently, when he is in full flow, it's all about he's telling the media, he's running it through like dramatically for them about, then he came in there, she came into the room and she fed him all this milk and did this, and obviously damaged the baby's throat, and there was a blunt force trauma to the baby's liver. So, for example, I think Stewart and Dr. Pittman were talking about that, and Dr. Pittman was saying with regard to baby O, he said, well, what about damage caused to the liver as part of the resuscitation process? So Evans wouldn't even consider that as a possibility. In other words, natural causes or murder. Natural causes or murder. It's like binary for him. It's one or the other. And he's not able, obviously, to understand what all the natural causes are either. So he fails on every aspect of it, because he doesn't understand. He doesn't care to look at whether he looked at the obstetric notes himself. I don't think Dr. Pittman is saying, what, they need to release them. Did he ever have sight of them and then discounted them, or did he wasn't even interested to look at the mum's notes, about the pregnancy before and then about the delivery? Did Evans was he even curious to look at those? Anyway, he's just a total git, but putting it mildly. I can't remember what I was saying before, though. I lost something, though. I was onto something. Let me look at my notes again. Yeah, a few other little bits. That's what I'm... His role in court versus his role with the police. When he's working with the police, he's not in court, obviously. So, but was his role with the police was obviously wrong as well, wasn't it? And they allowed that to happen. He became, I'm reading from my notes, he became a police detective to all intents and purposes. He was running it, really, but Hughes got the award. But Evans should have got the best SIO award, for what it's worth, which is nothing. Another thing here is that whether the onus was on Goss, and should have been on Goss, to stop him in court every time Evans went outside the bounds and started talking about elements of legal guilt and intent, about intent at all. And he should have kept with his within the limitations of saying, I can't find a natural cause for this. My theory is, for example, that air embolism was caused. It's not for me to say whether it was done with intent or not, just that it was caused. These are the mechanisms by which it might have been caused. I can't say what it was. I certainly can't say who it was, and I certainly can't say why they did it, and whether actually each individual case meant that an individual did these things as well, by looking at a rota, which he should never have had sight of either. Yeah. And then there's a relationship of Evans between him and the CPS stroke prosecuting team in the trial itself, how they utilised him, how they weaponised him as best as they could, in a way, So there's that relationship as well, and whether they did that in order to utilise him, and he's perfectly happy to be utilised, to be this weapon, but whether they are stepping outside of what should have been, what Goss should have called, that they're going beyond the limits of what they should do in terms of using Evans in that way, or using his reports in that way, perhaps more specifically. Yeah, I think that's it. I'll leave the link to that Northern Ireland case with the judge's statement about what expert witnesses should and shouldn't do in terms of. So in that particular case, it was to do with injuries, and there are injuries, and then there's injuries there were alleged injuries that caused death that were allegedly done deliberately, well, that's the point. As soon as you begin talking about it, you begin to stray into the area of intent. But his job, the discipline should be for a medical witness, is to never stray into that area of whether it's intent or not, just to describe what's going on. I'm assuming that's right. I get a bit stuck there because I don't know whether I did some questions, and it said here, this is from AI, but because I was trying to find out are there any instances in which intent can be inferred reasonably by a medical witness? And it said here, a forensic pathologist or expert witness can and often should provide a professional opinion as to whether a death was intentional, e.g. suicide or homicide, if it's within their expertise and based on scientific findings. I don't think that doesn't apply to Evans. That's not his that's not within his expertise, I don't think at all. That's the point, isn't it? It says, however, this opinion must be objective, based on evidence, and that's the point. Just saying, for Evans to bring in intent very, very quickly within 10 minutes, that's not based on evidence. That's just based on him deciding something and then working everything up to meet that decision, to match that decision. The opinion must be objective, based on evidence, and distinguished from legal determination of guilt or intent. So something could be done. A death could be caused. There's a bit of a contradiction here because it's saying about intentional death. But then there's you meant to distinguish that from a legal determination of intent. I can't quite work that out. It says here, distinguish cause versus manner of death. While a doctor determines the cause of death, hemorrhage, asphyxiation, etc., they may also determine the manner of death, suicide, homicide, accident, or natural. They may also determine it. Anyway, this is a bit generalized here. And I don't think he should have had anything to say about intent at all, much less the idea of helping to find a suspect or focus on a suspect by getting involved in staff rotas and stuff like that. But anyway, I don't want to repeat myself anymore, but yeah, the legal determination should be left to the court. But Evans is all over that. He crosses that line all the way through it, right from the beginning, really. And in effect, if you've got somebody running the police investigation, well, he's crossed that line, and it kind of irrevocably. I just want to end by saying this: is that's all terrible and awful, but the overarching problem is that he was allowed to do it. And finally, in the most serious staging point, he was allowed to do it in the court by Goss, the judge, maybe Goss was asleep. Apparently he was nearly asleep on a few occasions, according to some people who were there, or looking very tired anyway, and sort of drifting off, nodding off a little bit. There was nothing to stop Evans. That's the most criminal part of this. No one in the CPS, no one in the police, no one in the criminal justice system at all could stop this monster from doing what he did. Thanks very much for listening, and take care. Bye-bye.